Good afternoon, everyone, and welcome to the National Association of Criminal Defense Lawyers, or NACDL, as we refer to ourselves. I'm Norman Reamer. I'm the Executive Director, and on behalf of NACDL and the Foundation for Criminal Justice, welcome to Defending Protesters. This is the first in a series of training programs that we're going to be putting on to support volunteer lawyers who are participating in NACDL's First Amendment Strike Force and Mass Defense Initiative. Our goal with this project is to ensure that in a time of national turbulence, those who exercise their fundamental First Amendment rights to express their views in accordance with their conscience are provided with effective representation when the expression of those views results in arrest or prosecution. I want to thank the Foundation for Criminal Justice for making this possible. I want to thank Lisa Schrade from our National Affairs staff, who's been working for several weeks now to coordinate this effort, not just this training program, but to work with the volunteers. And I especially want to thank the more than 150 volunteers already who have signed up to be part of this project from all over the country. Thank you so much for making yourself available for this great project. This is a continuation of NACDL's commitment to rise to great challenges, especially when the criminal process is invoked in ways that challenge core principles. We have a long history going back to the defense of Native Americans at Wounded Knee. It continued with the John Adams Project when the association worked in partnership with the American Civil Liberties Union to provide representation for those charged at Gitmo who were not provided with qualified capital counsel. And it continued most recently until the end of last year with Clemency Project 2014, when we were proud to be part of a joint effort again with the ACLU and other wonderful groups in a project that led to the release of nearly 900 inmates, a tremendous, tremendous accomplishment. So with that, I want to introduce a remarkable faculty for this program. Lee Rowland is the senior staff attorney in the ACLU's Speech, Privacy, and Technology Project. She's a lawyer, a policy advocate, a litigator, a teacher, and an inspiration and a role model for all who cherish free speech. And Jeff Robinson is the ACLU Deputy Legal Director and Director of the Trone Center for Justice and Equality. Jeff is a crusader for racial and ethnic justice. He is a reformer, and near and dear to my heart, he is a terrific criminal defense lawyer who's devoted his career to defending people accused of crime. And I might add that Jeff was a founding lawyer member of the John Adams Project, and it was my honor to work with him and get to know him in that wonderful and very important endeavor. So with that, let me turn this over to Jeff and Lee, and thank you all for participating.
Norm, thank you very much. And just as we get started, let me say, Norm, your work with Anthony Romero on the John Adams Project is one of the most significant things of my career, and I have never forgotten it. And while I was cursing you for a while when I was on the military flights flying down there, the whole experience was life-changing for me. So it was something I'm really proud of, and I appreciate NACDL's commitment. And I'm thrilled to be here with Lee Rowland because I've been a criminal defense lawyer for 35 some years. And when I came to the ACLU, I thought I knew what there was to know about how the First Amendment impacted the issues of criminal defense until I sat down and started talking to Lee. And I got an education that I think the rest of us will get this afternoon. So I'm anxious for you to take a look at what we're going to give. And Lee, why don't you get us rolling?
I will happily do so. And thank you, Norm, for the kind, if embellished, bio, which I'll take. We'll make that my new official bio. And Jeff, the feeling's mutual. I love working with you at ACLU. And this is exactly when we get to marry our racial justice, our free speech work. Really a sweet spot for us and exactly what ACLU should be out doing. So our thanks to NACDL for making this possible. So we'll begin with a slide of the Women's March. And I put this up to illustrate that this is not discussing the rights of protesters at this moment in time is not merely academic. The Women's March was the single largest day of protest in American history, at least so far. I hope we top it. But lest I begin this slideshow by whitewashing the issue of those who will be facing criminal charges after participating in arrests, in protests, let me say this is not the image of the people who are likely to be your clients. Despite being the largest march in American protest history, the Women's March was not heavily policed, and it resulted in 0 arrests. Where we tend to see arrests are at robust protests that have picked up over the past year that I think could all fairly be characterized as racial justice-oriented protests. So we have seen mass waves of problematic arrests in cities like D.C., Ferguson, Baton Rouge, Standing Rock, Minneapolis. And so while this is an exciting time. People are active, right? We can see from the slide that people are getting out into the streets. I think we all have to be realistic that as criminal defense lawyers, you're more likely to see protesters who are perceived as challenging the state in a more acute way. People are perceived to be part of a movement to achieve progressive or racial justice. And so that's the first thing to keep in mind, is that you're likely to be dealing with someone who is a political person. So that leads us to, I think, our first big philosophical question that you as criminal defense attorneys have to grapple with, which is once you have a client, let's figure out who your client is and what they want out of a protest. So if you happen to have a relationship with this client before a protest, or say you have an ongoing relationship with someone who is asking you for advice about protesting, figure out, does this person want to be arrested? And I think the key as defense attorneys, and this is your bailiwick, Jeff, so I don't want to kick around your sandbox too much, but the idea is it should be an informed choice, right? If your client wants to break the law, that may be a valid goal for them, even if you can't kind of participate in that as an attorney. I think the key is ensuring that your client knows where that legal line is, and if they're stepping over the line into something that is more fairly characterized as civil disobedience, they should know that they're doing that.
And Lee, I think that's an important point because even for our volunteer lawyers, as you get more involved in this, you may be asked to speak to groups that are thinking about protesting or having representatives come to your office to talk with you about what it means to protest. And there are some people who may have a legitimate goal of, I want to be arrested along with 400 other people because we think we're going to make an impact on the system by having that happen. As Lee said, as lawyers, we can't advise someone to break the law, but we can tell them, this is what will happen if you do certain things, and this is what will happen to you if you're likely to be arrested. For some people, they may come to you because they're trying to figure out where the line is, because they don't want to be arrested. So understanding where the line is, and as Lee goes on, you'll see why I'm using that term of line, understanding where the line is really significant in the advice that you give to your clients.
So the first step is figure out, is your client attempting to engage in, say, high-profile civil disobedience, or are they trying not to get arrested? Now, it's not a guarantee, right? If there's over-enforcement by cops, that they won't get arrested, but at least then they've got a good chance of being innocent of those charges, either factually or constitutionally, as we'll discuss. So, and just a note, since we're sitting here at the end of June, I can't resist noting that right now there has this week been an incredibly high-profile act of civil disobedience while disabled individuals have engaged in sit-ins in congressional offices, including of Mitch McConnell. And we have seen image after image in the media of Capitol Police carrying disabled people out of the hallways, often without their wheelchairs. And you could see how an activist would see that as the goal, right? Knowing that they're going to get arrested and producing that kind of impactful image. So again, as a lawyer, you can't suggest that. You're generally ethically not supposed to encourage that, but you can make sure those people know what the risks are, right? And protesting in the Capitol, that may come with a criminal charge. So along the same lines, after arrest, you're going to want to go through, I think, the same kind of analysis with your client. The first is, Does your client want to plead or fight the charges? And you guys know better than I do that that may be as much a practical decision as a political one. So someone, for example, with a full-time job who doesn't have the resources to be missing that for court dates, pleading guilty may be their only practical option. For other folks who may be part of an organized resistance action, actually clogging up the court system by pleading not guilty and insisting on their day in court might be one of their goals, again, to increase the visibility of those arrests. That may go hand in hand with folks who are engaged in intentional disobedience. I think that has to be the starting conversation here.
And Lee, I agree with you, and it's important because as I think everybody who is a member of the NACDL knows, this kind of representation is not about the lawyers, it's about the clients and about what the clients want and what the clients desire. Someone may want to fight the charges because in certain states there is a defense that's written into statutes that's generally known as a necessity defense. A defense that says you can actually break the law if what you're doing is in breaking the law is less significant than the violation or the problem you're trying to solve. It depends on what state you're in, but having and understanding what the law is in the state is critical so that you can give a client that kind of advice. When Lee said there are some people who can afford to plead guilty and some who can't, one of the things that we know as criminal defense lawyers and at the ACLU is that issues like bail can be deadly for some people. People get arrested, they can't bail out, they lose their job, they lose their apartment. It can literally be the line between having a quote-unquote stable life and ending up homeless. So understanding what the rules are in your jurisdiction. Are people going to be released on PR so that they can come back to court? Are they going to stay in jail for some period of time before they can make a court appearance? Or is bail going to be required? These are the things that you need to understand as the case gets started. And my advice is that you want to understand what your client wants to do. It is not what you think is best for the client. It's helping the client make that determination with their own views and their own goals in mind.
And one additional factor to consider in that conversation is if you have a client who is part of an organized action, for example, Black Lives Matter, if they're part of that group, it is very common for community organizers to put together a bail fund, a community bail fund in the wake of any large arrests. So as your attorney, if you are representing a client who is part of a large group of arrests, you're going to want to look out there, online, on Kickstarter, GoFundMe, and see if someone has set up, or on Facebook, and see if someone has set up a community bail fund, because that may make the difference to your client in the ability to be released or not. And they become more and more common over the past year with organized arrest actions. So, in order to figure out whether to plead or fight the charges, of course, a huge part of what you're going to assess is, are there going to be any constitutional claims that this arrest was invalid? You guys already have the tools as defense counsel, I assume, as a general matter to contest facts, right? This just didn't happen that way. That's a lie in the police report. But with protest, you always want to have a second layer, which is looking for constitutional infirmities in any charging instrument. And that can happen two ways, and we'll try and break those. The whole point of this webinar is try and break down where the line, as Jeff refers to it, is, as best we can. There are entire case books on this stuff. But to try and figure out, is this a law that may be invalid on its face, in which case there may be a facial constitutional claim? That's the kind of case where you want to be sure to call your friendly local ACLU attorney, because those are the kind of cases that our affiliates bring, challenges to the law itself. Alternatively, you may have a valid law, but that's been applied unconstitutionally, and largely those will be due process issues. For example, someone isn't given adequate notice of a dispersal order during a protest. And again, we'll talk through those in a little bit more detail, but those are something to keep in mind. So there are two different possible layers of constitutional infirmity you can look at. The law on its face doesn't cut the mustard, or the law might, but as applied to your client, it's a problem. And in either of those situations, especially if you've got a vulnerable client who does not have the time and resources for a long appeals process, one option to consider is whether an Alford plea might work in any particular case, where you're effectively going to plead but reserve the right to challenge that law as unconstitutional or its application in that
And I think
case.
that's really an important point, because there are some folks who would be more than happy to have an appeal process after a conviction, because for whatever reason, if it's a misdemeanor, they can deal with the conviction, their job isn't going to be an issue, and so they're happy to have the constitutional issue raised on appeal. What they're not happy to do is to go through the trial process. And so this is one way where you can potentially preserve the constitutional issue on appeal, but tell your client you're not going to have to make repeated appearances at pretrial hearings, at readiness hearings, or whatever they're called in your state. So we're not suggesting plead a client guilty. What we're saying is there is a way to challenge the constitutionality of either the statute or the method of arrest without going through the entire trial process.
And the benefit of that from a ACLU point of view is that what we tend to do is impact litigation. We will challenge a law on its face. The majority of the time we're looking for that kind of infirmity rather than the as-applied factual problem that you might have in an individual client's case. When we bring facial challenges to laws arguing that they are unconstitutional, we have one of the many obstacles procedurally that can get in the way is younger abstention, which is the federal courts will generally not assess the constitutionality of a criminal law if it is in the middle of being applied by a trial court. They'll give the trial court the space to get rid of the as-applied wrinkles. And so for us, an Alford plea gives the ACLU or another impact litigation group an entry to bring a facial claim against a law without worrying about younger abstention and being unable to do so until the case is closed. So just procedurally, if you are working with litigators who are going beyond just the sole client and looking to challenge the law, Alford pleas are a wonderful way to do that if it works out for your client.
And I just want to say, this is another thing about advising your client about what's possible, because people may be very, very, very informed on the issue that they are protesting, but they may be very uninformed on the potential consequences.
So let's get to the nitty-gritty of all the stuff we're talking around, Alford pleas and appeals and facial challenges, and try and figure out how you can quickly issue spot whether you may have a First Amendment problem with one of your client. And if you remember one line out of this webinar, this is the line to remember: protest rights are property rights.
And can I just say,
Yeah.
when I first saw this slide and when Lee first told me this, I thought, that makes no sense to me whatsoever. How a protest right could be a property right. But thinking about it in that way will, I guarantee you, help those of us who are criminal defense lawyers understand the line that I'm talking about and understand the factual nuances that can drive a case one way or the other.
And on a gut level, I'm sure we all understand some version of this, at least as it pertains to ourselves, right? We probably think on a gut level we have a lot of rights at home to do pretty much what we like to do. But if we're at somebody else's house and we get up on the dinner table and start ranting about the gold standard, we might not be shocked if they ask us to leave at some point. I don't know your friends, but I think my friends probably would ask me to go at that point. And so we do, I think, have a gut understanding of this as your rights depending on the kind of property you're on. And when we're talking about governmental property, there is a similar parallel spectrum. There are things that are more akin to being at home. Your public lands, your parks, your streets, your sidewalks. That's what's called a public forum. And the public forum is just the fancy legal term of art for where our First Amendment rights are at their most robust. And so it's akin on that spectrum from your house to somebody else's house. The public forum is you, as a citizen, have the most rights to be at home on public property. And there are really just three traditional public fora. You can see here one of them, the original suffragettes, occupying a good chunk of the street, wishing Ma could vote. I'm sure they would be heartened to see at least some of the subsequent developments. And the street is the first one that the Supreme Court, in one of its earliest cases, trying to figure out what do we do with this First Amendment thing, said streets and parks, and I'm just going to put in a friendly asterisk and say it's streets, sidewalks, and parks. And I say that because the rules of the game are a little bit different on streets and sidewalks. So streets, sidewalks, and parks have immemorially been held in trust for the use of the public. You can read this beautiful language for the purposes of assembly, communicating thoughts between citizens, and discussing public questions. This idea of a robust democracy, and where does it happen? It happens in the streets and in the parks of our public property, the beating heart of our society. And that's akin to our rights at home. So what this means is, in a public forum of any kind, the government is going to have to do a very good and reality-based job of justifying any infringement on speech in those three places. So we'll go through them because there are a few differences between streets, sidewalks, and parks, but that's the big philosophical top line to remember. If your client is in one of those spaces, they, by default, have a right to make their voice heard there, and any restriction on that is going to face real and meaningful scrutiny from the courts. And a general way to think about this is you could still be arrested for throwing a brick at someone, right? Being on these places gives you absolutely no extra right to commit assault or another crime, but they do give you a good constitutional buffer from arrest for trespass, or disorderly conduct, or the kind of mushy mistos that tend to get thrown at people speaking their voices in public. So if your client's in one of these places, you should perk up and start to think, hey, maybe I can attack this arrest as invalid. So here's a street. Streets are a great place to protest. They are theoretically open at any time. The reason I say theoretically is because in the last year, we started, I mentioned some of these protests, many of which have been organized around racial justice. We have seen in a nearly linear fashion almost every state with robust racial justice protests pass robust anti-protest legislation, or at least propose that legislation. That fortunately the majority of them have not passed, at least thus far in the session.
And so, for example, I think it was in South Dakota, one of the laws that was proposed was that if a person is driving a car and they hit a protester, they can't be charged with a crime. I mean, essentially, I'm paraphrasing it, but that's essentially what it was. Yeah. If you hit a protester, that's okay. And what they were saying is, we don't want these people in the streets, and one way that we can make it clear that we don't like this is to give drivers carte blanche. If, hey, you want to get home and the protesters are delaying you, just kind of bump them with your car.
And the first thing I want to say is thanks, because anybody watching this, you have a vital piece to play in being, I think, a counterweight to the kind of chill and self-censorship that is the intended result of the introduction of this kind of state legislation. And so I think all of us in the civil liberties and the civil rights and the defense communities need to be an important balance to remind people they have every right to go out in the streets and protest, despite some of the rhetoric that's gone around these anti-protest bills. And one of the most important bits of rhetoric has been ambulances won't get to hospitals on time if people fill the highways, okay? There may be a superficial appeal to a statement like that, but number one, purely and totally hypothetical. For example, I mentioned the Women's March completely shut down the city of D.C. Absolutely not a single report of anyone, being delayed 5 minutes, getting to the emergency room with a sprained wrist, let alone the kind of hysterical people dying on the highway, stranded stories that some people have told to justify this kind of legislation. But the second thing to say is that The First Amendment right to protest is what we call a foundational right. It is fundamental. It is in our Constitution. Your ability to pilot a car somewhere and get there on time, while certainly an important part of the fabric of everyone's daily lives, does not reach that level of constitutional protection. So simply invoking the idea that someone in a car might be inconvenienced versus someone having their voice heard in the street should not be a rhetorical trick that we fall for. And so what these states have attempted to do, both rhetorically and legally, is to kind of flip the script a little bit so that there's an asterisk on streets. So it's now, unless there are too many people or unless we're talking about a highway. And let me just say, there's some theory in this, but there is not a single federal case that holds, oh yeah, when we said streets, we didn't mean highways. So if you have a client who is arrested because their local jurisdiction has decided that highways do not count as streets for First Amendment purposes, take a second look at that. Call your local ACLU. If you are in South Dakota, North Dakota, Oklahoma
Right.
in particular, keep your ears to the ground for that kind of arrest. Now, as with both sidewalks and parks, the general rule for streets, less so with parks, but the general guideline for whether or not your client's behavior is going to be constitutionally protected is going to be one of obstruction. Obstruction meaning that you intentionally and knowingly place yourself in the way of traffic such that you stop it. So what that means, putting together, I've now told you there's generally a right to protest in the streets, but I've now told you that you don't have a right to intentionally obstruct traffic. Here's what that means. If you do not have a permit, if you have not approached the government, your First Amendment right basically extends to walking single or double file down the breakdown lane of any street, such that you can be visible, you can be heard, but traffic can continue to move by.
And Lee, that is such an important distinction, and one that I did not understand when we first started having this discussion, because I thought if you don't have a permit and you step off the sidewalk, aren't you vulnerable at that point? But when we stop to think about what would be the purpose of keeping a person off the street, and just look out the window wherever you are, you will see people in the street all the time, and none of them are getting arrested because they're not blocking traffic. And so even without a permit, two people on either side of the street walking down the street with a line behind them, the traffic can get through, people can make turns, so you're not walking against the lights or anything like that. This gives you that layer of constitutional protection that may not be obvious to people at first.
And let's break down maybe a factual hypothetical to illustrate whether this might be a facially invalid law or an application that you should be concerned about factually to your client. Let's say your state has passed a law that says people can't be in the breakdown lane or it's automatic arrest. That's a facial problem. We have a First Amendment right to protest in the streets. If, however, the more likely situation occurs, which is this: breaking news happens. Let's just say, theoretically, for statistical purposes, a white cop shoots and kills a black man. And this happens in a small city, and there is immediate outrage, and people intend to get out in the streets. Word gets out on Facebook. Let's say there's a local Black Lives Matter meetup group. Anyone who's subscribed says, action, will meet at the corner of 4th and 27th. Now, because of the breaking news, far more people show up than anyone has expected. And it is not physically possible to remain single or double file with the number of people that has organically massed into this area. And this is a pretty likely situation, and it's what's happened in many cities. In this situation, you may get a collective group of people that is obstructing traffic. But I would argue, and you should argue on behalf of your client, that your client did not knowingly or intentionally seek to obstruct traffic, that the mens rea was missing, or there might be a defense of necessity, which are two halves of the same coin, right, Jeff?
Exactly.
And these are situations where, because of the organic massing of people, no one has gone out to throw themselves in front of an ambulance, right? They've gone with every intent of obeying the law, but the situation collectively has become an obstruction.
And now what we're talking about now we're really digging into the facts. How soon after your client showed up was he or she arrested? If it's 5 minutes and they show up thinking there's going to be 50 people, and there's 500 people or 5,000 people, and it's like, oh my God, I had no idea. And as you're standing there and the crowd moves, you find yourself in the street. Factually speaking, I think I have a legitimate defense of I had absolutely no intent of obstructing traffic. I got caught in a crowd, and I couldn't move out of the crowd before I was arrested. So timing is critical, and this is where, if there are news services or people with cell phones, you want to get the video. One of the things that your clients may have if they are carrying a cell phone, if their GPS monitoring is turned on, you may be able to demonstrate later in court what time your client got to the corner of 4th and 27th. And if they're arrested 3 minutes later, then you've got a very strong factual argument that, hey, this just happened to them and that this was beyond their control. So these are the kind of things that you might not think of initially, but there are ways to take on these statutes that are really substantive and can keep people out of jail.
And since you brought up discovery, Jeff, it's probably a good place to note that as far as discovery, it can go both ways in the sense that you should probably inform your client that at most street protests, the odds of them being on camera for most moments of their interaction is probably close to 100%. And so that's both an opportunity in terms of getting discovery materials, but it's also, I think, important to ensure your client knows that they'll be accountable for whatever story they're going to tell. And that's doubly so with body-worn cop cameras, right, which again are another stream of potential discovery for you. But it also means that your client should understand that whatever story is their story, it's likely verifiable when they're out protesting in public. And this is a bit of a rabbit hole, but it's become so prevalent, it is important to note that police have now taken to delivering subpoenas or even full warrants for social media content for known arrestees looking for their associates. So, for example, and sometimes these are accompanied by gag orders. So, to give an example, there is one right now that is live in the District of Columbia Superior Court, so not the federal court, but the local appellate court here, where there is a case that's completely under seal. To the point that, say, were we interested at filing something in the case, we wouldn't know who to serve it on.
Right.
And what they have asked Facebook for are the contents, communications, all private messages from 3 accounts. We have no idea what it's about, but I did live in Vegas for a while, so I'll be willing to say I put $20 on the fact that they are looking for the Facebook accounts of people who were arrested at the Black Bloc protests on Inauguration Day. They want to know everybody those people were with, and they want to find felonies to gin up against those people because obviously the police were not present to arrest for misdemeanors. So if you see that kind of invasive subpoena or warrant process, a little Fourth Amendment flag could go up. I know we're talking about protest rights, but being an all civil liberties shop, I would tell you that's something that is also challengeable if they're expanding electronic surveillance in that way, especially if it's under a gag order. It may place your clients, loved ones, and friends at risk, so it actually might be directly within your purview as someone who's representing them, not simply a public service more broadly. Okay, so we've mentioned in passing street sidewalks, parks. So sidewalks here are a great place to protest. You can see this was I'm not sure if it's still as vibrant, but there was a pretty much ever-rotating protest in front of Trump Tower for at least the first 2 months after the election. So you can pretty reliably see some version of this protest in action if you happen to be in Manhattan. Now, sidewalks and streets basically have the same rules. Meaning that the name of the game is obstruction. Here we're talking about obstructing pedestrian traffic. And one thing to look out for as far as facts and assessing whether or not your client has BS charges is to look for related activity that is not political. So, for example, someone hanging out on the sidewalk giving you Domino's coupons, or, I'm sure there are all kinds of things.
Imagine the person in the bank who's dressed up in the goofy uniform with like a thing they're twirling around. People have to walk around them to get down the sidewalk. This morning, as I was coming to the train station, Penn Station in New York, there was a man that was sleeping, and the police officer walked up to him and said, "Hey, it's rush hour. I wouldn't mind if you were laying here in the afternoon, but right now it's rush hour." And what the guy did was to move slightly so that he was laying in between two columns where nobody was really walking. And the officer, you could see the officer, and the officer was like, "Yeah, I'm going to go away and come back and see how this is going." So he moved so that he wasn't blocking the traffic anymore. And I think that's just something to be aware of. And this is, again, where video and photographs can come in, or even sending an investigator to the very place where your client was arrested to see what kind of obstructions are there on a daily basis, that are always there, that the police never do anything about. And if you get lucky, you actually may have a videotape of somebody obstructing the sidewalk and a police officer right in the area and doing nothing about it.
And the reason that everything Jeff said is so important is because the biggest weapon you have under the First Amendment, if we're in any of these public forum spaces we're discussing, streets, sidewalk, parks, if you can demonstrate that someone was charged or treated differently because the content of what they were doing was expressive, that's pretty close to a QED. The government can't do that under the First Amendment. And so if you're able to muster evidence to demonstrate they arrested the protester for obstruction because somebody had to take 2 steps around him, but they left the homeless guy sleeping as long as he could be out of the way, that's pretty close to a win. At least if you get those facts in the record, your average appeals court should say, that's not valid. That's an invalid government interest, because clearly what you actually retaliated against was the content of the speech, not any actual obstruction. So that kind of discovery worth its weight in gold. The final public forum space are parks. And let me say, I realize there's a bit of Pollyanna-ish to all of this, in the sense that the actual medium for today's average speaker is likely Facebook or Twitter or another forum online. But our First Amendment law is either not competent or has not caught up to our technological developments and doesn't quite know what to make of those spaces yet. And because they're not physical, it's very unlikely that your client will be arrested for protesting online. So let me say, I recognize that some of these are almost quaint in their physicality, but the vast majority of cases you'll be dealing with will be analog cases, not digital. So parks are now a good time to synthesize a few truths about public fora more generally, and there are 2 that are really important to note. The first is the role of permits. All 3 spaces can theoretically be permitted: streets, parks, and sidewalks. Sidewalks are the least likely to be available for permitting. So in some ways, sidewalks have an appeal in that they're kind of always open. Nobody's ever going to steal a chunk of sidewalk. And if you've ever been to a massive march in New York or DC, you'll see that people who have obtained permits may get entire avenues cordoned off, but the sidewalks are theoretically free. And in practice, protesters may fill them up. And of course, since it's the Women's March or whatever, nobody's getting arrested. But technically, those sidewalks are not generally part of the permitted area. They can be in some cities, though, so you want to check your local rules. Usually that's done at the city or county level, that kind of ordinance, zoning ordinance. When you have a permit, there are huge benefits in terms of ensuring that law enforcement is on notice about the kind of volume that's going to occur. It generally avoids communication-based misunderstandings, and it makes it much, much, much more difficult for them to issue any kind of dispersal order or anything that might lead to misdemeanor charges for anyone who is just having their voice heard. On the other hand, there are many groups who have no interest in playing nice with the government in advance of a march, and they don't have to. But if you don't have a permit, there are some real limits on you. Number one, you're always going to be subject to obstruction rules. So if a bunch of people show up at an event that you called in a park, you may have the cops coming and telling you, no, you have to thin everybody out 2 by 2, which is not going to be a powerful protest, or they're going to issue a dispersal order. So you do create more legal vulnerabilities even in these public spaces if they get overrun and the cops feel like they can't administer it safely, that there's a risk to traffic, there's a risk to safety. And sometimes those risks risks are overblown, too. I'm not saying they're justified, but it gives them the wiggle room to create dispersal orders and things that could lead to misdemeanor charges for protesters and people who might be your clients. But again, your clients don't have to. They may be people who don't want to liaise with the government, who may show up, and they may have fewer rights when they do that. With parks, with almost every park in the country, most parks have a number. They have a trigger number. It's frequently around 30 to 50 people, where if you knowingly bring that many people to the park for a single event, it triggers a permit requirement. It is not optional. So if you are definitely going to have an event in July, and you're putting it on Facebook and you're sending it to 3,000 people, and you don't get a permit, you could theoretically be legally liable for disruption, for failure to get a permit, for trespass, if you were the organizer. Now, there's even an asterisk to that asterisk, which is the breaking news exception.
Right.
So the courts have said, permits are important because we don't want the pretty grass ruined. That's kind of, I'm obviously paraphrasing a little, but that, the idea is that there's land management needs. And hey, there might be two groups who want to have a big protest and they all show up without notice.
Right.
It's a mess. So they've said, as long as it's not about your message, as long as they're not saying, are you Black Lives Matter or are you an alt-right group, right? Then the government can require permits to manage the land. But the exception is this: there is literally a breaking news exception. So if that white cop kills a black man and outrage organically bubbles up through the community, the courts have said that using a permit requirement to tamp down that expression is unconstitutional. And you may very well be representing people who are protesting in response to breaking news. And that's important because it expands some of the First Amendment protections your clients may have.
And I think when Lee talks about breaking news, there are two things to remember there. There is the news breaking in the sense of the incident happened at 6:30 on Saturday. The public may not be aware of that until 8 o'clock Sunday morning.
That's right.
And so the breaking news is not necessarily when the event happened, but when that information is put into the public domain so that people can respond to it. And so this is once again where, just in talking with Lee about this, one of the things that I have felt like is video and time. I want any kind of video and any kind of timing that will show me where my client was and how long he or she was there before something happened. And those two things, I think, can often be really, really substantive in putting up roadblocks for the government to try and convict our clients.
Hugely. And they're all the more important if the charge that your client might get is a failure to disperse order.
Yes.
And now these charges, by the way, will be grouped differently in different states. So I think in New York, disorderly conduct has two kinds of disorderly conduct, and one is failure to disperse. You should look at your local statutes for whatever quirks they may have. So, for example, in New York State, disorderly conduct is a common law breach of the peace statute, and there has to actually be members of the public to be whose peace is breached. And police officers under state law have been assessed not to count as members of the public, in the sense that they can't arrest you for annoying them.
Exactly.
You have to annoy the public first.
And if you think about it, this is kind of it's a bit of a stretch, but think about Professor Gates being arrested in his own home. Mm-hmm. And think about the fact that he was arrested for disturbing the peace or disorderly conduct.
Great example.
And who was he disturbing? Because what he was doing was standing on his porch and in a very loud voice saying, "You think this is the end of this, but this ain't the end of this, guys. I'm coming after you." There were people walking by on the street, but there's no evidence that they were disturbed by him saying this to the police officers. Who was disturbed were the police officers. So it is a critical thing to go and look at that statute. And I think the rule that Lee just talked about, saying cops are sort of cut out of the group of potential disturbees, a really, really critical thing. I will just mention one other thing that happened in Milwaukee, Wisconsin. The ACLU has filed a lawsuit against the Milwaukee Police Department, our national office and our state affiliate, and a law firm from New York. It's a huge pattern and practices lawsuit. during a protest in Milwaukee after one of the numerous killings by the Milwaukee police. There were 3 people standing on a sidewalk in front of a person's house, and the person had been complaining about these people are disturbing my peace in my home. The Milwaukee police arrested these 3 people, then found out one was a state representative and the other 2 were ACLU employees. The charges were dismissed. In my view, any other arrest that occurred on that day is subject to question in that area, because they have demonstrated that once they found out who these people were, it's like, oh, well, we're not going to arrest you, in part because you're a state representative and the ACLU might actually do something about this, so we're going to let you go. But you other folks that don't have those affiliations, we're happy to arrest you. Those are the kind of facts that we're looking for, so that we can show a court it's the content of the speech, not the person standing there, that is really what's going on.
Absolutely. And not only can discovery help you suss out the differences in enforcement, but they can also go to those quirks in the state laws. So, for example, was there someone offended who wasn't a cop?
Right.
Or, and this, please, please, please take this to heart, second only to property rights or protest rights, is most of these misdemeanor statutes have some kind of specific intent.
Yes.
Not just generalized mens rea, but, for example, the anti-masking statute, which, by the way, was passed initially to stop the KKK from holding marches on the highway, almost never enforced. We've magically seen enforcement of mask ordinances lately against, for example, Standing Rock protesters who were wearing bandanas over their mouths to stop tear gas from getting in their mouths. So, for example, most masking statutes say with the intent to disguise themselves for the purpose of intimidation. Well, if you've got a client who said, I was just trying to breathe, fight that intent element, right? So, and same thing with obstruction. If you've got clients who said, hey, I showed up, this sounded like a great protest, and all of a sudden I couldn't physically I couldn't get onto the sidewalk, challenge that intent element. That is not someone who is knowingly and intentionally obstructing traffic in any way, right? They're there through no kind of fault of their own, legally innocent mind. That matters hugely in almost all of these misdemeanors if these folks are lucky enough to have a counsel to take them seriously.
Exactly, and that is one of the things that I really want to emphasize is the way these cases end up getting dismissed in huge numbers. A lot of times, you will never get to the issues Lee and I are talking about. Have 500 people get arrested and have all 500 of them say, we want a trial. And see what happens in a municipal or district court when that kind of volume is thrust on the court. What you're going to have is prosecutors who are starting to say, well, how about if I give you a warning, or how about if you take this, or we'll let you out of jail, and cases are going to start to disappear. So by using these constitutional protections, part of what you're doing is telling the court where these laws are trying to be enforced, we are going to bury you for a very long time with legitimate legal issues, and now they have to decide, is it really worth it for our court system to take this much time on cases that they know they don't care about that much. They know these are not people that are going to go out and commit crimes and that we have to be afraid for the safety of our community. They know that. And when they know that and all of a sudden it becomes a much bigger lift, some people aren't willing to make the bigger lift.
So we've now kind of come to the end of public forum property, street, sidewalks, and parks. These are where you have the strongest arguments. If you have any discovery that demonstrates your client was singled out for their views, for speaking out, for being part of a protest, you've got a great defense on your hands. But there are a lot more government properties than that. And as of late, we've actually seen protest expanding into these areas. I'm going to go over them somewhat quickly because I think it's less likely you'll have a client from these areas, but I'll hopefully give you a few guidelines. So the first one, and honestly, until this year, I didn't realize I'd have to work it into my Know Your Rights materials. Who knew that people would go to JFK voluntarily? But we found out what would make them do that. And it turns out a discriminatory and racist Muslim ban on refugees entering our country. So this is one of the protests at JFK in the wake of the executive order banning certain refugees. And this is a protest that was managed in the sense that there were observers from both the ACLU of National, from the New York Civil Liberties Union, and from National Lawyers Guild, all in real time liaising with airport staff who, similarly to me, did not realize that they were going to need a First Amendment 101 when they woke up in the morning at their jobs at the airport. Considering that, actually, JFK handled it pretty well. They got up to staff who actually talked to folks and realized that they had some constitutional responsibilities not to kick everybody off of airport property. But you will see that this protest is outside, and there's a reason for that. When we are talking about government properties that also function as businesses, we are no longer talking about public forum space. We are now talking about something that is either a limited public forum or a non-public forum, and those are just legal terms of art for how many First Amendment rights you have in that space. Airports, and I'll mention quickly courts and government meetings in the next slides, are all examples of these limited public fora where you have some speech rights, but not as many as you would have in a street or a sidewalk or a park. And that difference in legal terms is that generally, before I said the word was obstruction, right? We're going to shift that word a little bit. In this kind of government property that has a business, the word of the day is disruption. Anything that disrupts the business operations of that government property is generally going to be okay to criminalize, assuming other due process and elements are met. But now there's a little difference. I said before, if you find evidence that somebody is charged because of what they said, that's boom, you're done, QED, right? That's a great argument. When we're not in public forum property, that's no longer true. Give you an example. I go to a public meeting and I stand up in the middle of the meeting and I yell, "You lie, you lie, you lie." Do you think I can be removed by security? I can, but they're clearly removing me for what I'm saying, right? And the reason is because at that point, the rule isn't obstruction, the rule is disruption. I'm disrupting the meeting. So that is the basic philosophical point that's going to apply, and that's going to look different depending on the kind of business. So an airport, the purpose is air travel. But part of air travel is, people coming home and holding up signs that say, "Welcome home," right? So obviously the airport has decided it's not disruptive for you to stand around and passively hold a sign. However, the Supreme Court has ruled that solicitation can screw up pedestrian flows in airports.
Think about the Hare Krishnas.
And that's the case. The case is a Hare Krishna case, and they basically said, you guys are going through the airport asking for handouts. It's gumming up the works, so you can't do that. So this became a really interesting question. We now had lawyers who wanted to offer their services to people coming through, Border Patrol, who had signs that said, "I'm a lawyer, come talk to me." And we as ACLU would absolutely defend their right to do that. It wasn't an in-person interaction, it was a passive sign. It's absolutely our job to do that. Will I admit, if put to the screws, that there's a little bit of theory in saying that you clearly have that First Amendment right? Yes. I still think we'd win that case, but it's a little bit of a grayer area, right? Because the first job of the airport is to make sure people can engage in air traffic. And even though they can get you on disruption, there's still a great ironclad First Amendment rule that applies no matter what kind of property you're on, which is the government can never single you out for your viewpoint. So if on a government agenda they say you have to stick to the agenda topics, that's valid. That is a content-based restriction under the law, means they can tell you what kind of stuff you can say and what you can't say. Stick to the agenda. What they can't say is, we welcome all pro-choice comments, but we will not hear from anyone who is anti-abortion, right? So they can't introduce a topic and then say, we're only taking advice on this one viewpoint. And so for us, I might look at, if they had said to lawyers, you can't tell people you're looking for assistance, we might have argued, well, that's attacking a viewpoint, because they're fine if you say, welcome home, love your family, but they're not fine if they say, welcome home, I'm an immigration attorney, right? Those are still, the rule is still that the government can't pick and choose based on viewpoint, but it can get its job done. And the other key rule to remember, other than not discriminating based on viewpoint, is that the closer you are to where the business gets done, the more power the government has to restrain you. So in an airport, those protests were outside. You can't have them in the terminal. You just can't. No court is going to say you have that right. Speaking of courts, there are a lot of special rules for courts who I am sad to say perhaps are not as welcoming to
Yes.
opening their own lawns and backyards to protest. This is a view of the Supreme Court Plaza, which the Supreme Court has upheld as not a public forum, even though it looks remarkably like one in that image
Sure
to
does.
me. So, and courts, the general rule will be you can't stand up and yell anything in the courtroom. You'll get kicked out, right? The closer you are to that business here, a court action, the more power the government has to keep you from being disruptive. Unfortunately, even the steps of the Supreme Court and the plaza are not public areas in D.C., but the second you move over onto that public sidewalk, we get right back into public forum land and your First Amendment rights get ratcheted up. So again, property rights are protest rights. Just that 1 foot step between the Supreme Court Plaza and the sidewalk around it will determine whether or not what you're doing is protected by the First Amendment. And the final government property I think it's worth meeting is government meetings. I've already mentioned that in this kind of limited forum, the government can set content rules. They can say, only stick to the agenda, or this is a meeting about water quality, right? And we're not hearing a stump speech on racial justice right now. They can do that, as long as they would also, by the way, shut down the stump speech on environmental justice, or whatever that, right?
Exactly.
As long as it was similarly applied. And so here's the doctrinal test. If you are in this kind of government space that is not a public forum, if it's a non-public forum, at a minimum, the government must be viewpoint neutral, okay, which we already talked about is the difference between two opinions, and it must be reasonable. And there's been a lot of ink spilled into what that reasonable means. But we've seen a few tests of it in recent town hall meetings, especially by federal legislators. Two of them that have cropped up a few times are no recording and no signs of any kind. Not even like no signs over 8 square feet that could block somebody's view, but no signs. While those may not be based on viewpoint, I think they're unreasonable. I think having a government meeting with the purpose of which is to listen to and interact with citizens and tell them, except for don't bring any of your pesky opinions in here in a way that we can see, I think that's unreasonable. So I mention that only because, again, there may be some theory in where I think the law should be. But if you get someone who's arrested at a government meeting because they took out their cell phone and recorded a public official at a public meeting saying something about public policy, or you get someone arrested because they wore a button on their lapel or had a tiny sign, challenge that business and call the ACLU.
And I think that's one of the important things about everything that we've been talking about. You will have some clients who want to challenge their arrest in any way, shape, or form possible. And so there is a whole smorgasbord of potential challenges that are here. And I think this is one of the things that, as people come to you as members of a group or members of an organization, and they're trying to figure out what can we do, what can't we do. I think this is going to give you a lot of ammunition in terms of how you advise clients, what you're telling them about what they can and can't do. And you can tell a client, this is risky, but there is this constitutional protection. And if you're willing to go and do this, then we can raise this issue when we go to court, and we'll see what happens. There are a whole lot of people who may say, that is exactly what I'm trying to accomplish. And I guarantee you, there were people that we heard from in South Dakota who were saying, I am willing to stand in the street and get very close to a car to see if they're going to actually try and enforce this law if they pass it. So once again, it's about understanding what the client's goals are and how we as lawyers can advance those clients' goals within the Constitution and within our duty as lawyers.
Amen to that. So that's the end of my attempting to prove my thesis: protest rights are property rights, with one very modern digital asterisk, which is the general rights we've laid out also apply to your right to photograph. And the right to photograph is probably a little too complicated to get into as granularly because there are different situations, but the same big picture philosophical rules will guide you. If you are in a public space outdoors, there can be no restriction on your right to photograph. Absent, unless you are literally taking upskirt photos or using a zoom lens into a private area of, like, with the exception of peeping Tom or doing something that you know you shouldn't be doing. Generally, I'm not considering those protest defendants. I'm considering them something else. Those, generally, there can be no restrictions on your ability to photograph if you're in an outdoor public space and you are somewhere you have every right to be. Now, I wish that were 100% true. We are actually litigating what I hope is a very tiny asterisk on that right at ports of entry. That is to say, journalists and citizen activists who saw Border Patrol guards physically assaulting women and taking pictures of it while going through outdoor ports of entry spaces. We're litigating that, and we're fighting the charges that our clients received in those cases. I think ultimately will prevail, and there will be no asterisk on that right to photograph things that are in public view, because, my God, if our government is so fragile that we're going to be taken down because a tourist took a Polaroid in the middle of an outdoor port of entry, we're all screwed for much bigger reasons than the fact that somebody took a photograph. Nonetheless, Border Patrol, doesn't have a reputation for being terribly tolerant of constitutional rights or anything else, and so they have attempted to stop people taking pictures at ports of entry. So that is the one asterisk on the outdoor public spaces that I can think of. Otherwise, if you have a client arrested for taking a picture, challenge it, appeal it, that is a case. You should be winning those cases. The vast majority of BS charges I've seen will be for obstructing an officer in the performance of their duties. Taking a photograph alone can never meet the element of obstructing an officer. It has to be about physical proximity, or the trickiest one, using a flash at night in a way that might blind an officer.
Exactly.
In any of those situations, though, I would focus on the intent and the notice to the person. Like a dispersal order, an officer's decision about how much space they need without being interfered with is generally ad hoc. Most state laws do not say that obstructing an officer in the performance of their duties is getting closer than 18.2 feet. They don't say that. They leave it at the individual officer's discretion, and so it's your job to interrogate that discretion heavily in terms of distance, in terms of actual obstruction. The fact of recording alone cannot be a factor in the obstruction. That just means I'm embarrassed for people seeing me do my job in public. Not a valid reason. And the other thing that's really important to know on the right to photograph, it's not just a First Amendment concern, it's Fourth. If you ever have a client who is told to turn over their camera and police look through or, God forbid, delete those images without a warrant, that is a classic Fourth Amendment violation, and you should challenge it. As such, if there's any evidence obtained from that action, it also just may lend its way to a civil suit that you may want to recommend to your client that could give them leverage in any plea deal in the criminal case.
Exactly, because if there are civil rights that have been violated, I can't tell you how many times I represented people where what the government wanted, they come and say, oh, we'll dismiss the charges, we just want you to stipulate to probable cause. Because if you stipulate to probable cause, many government lawyers feel like I now have a bar to a civil lawsuit. Because I can say, even if I was wrong in what I was doing, if I had probable cause, then my actions weren't unreasonable, and there's not going to be any civil liability. For some of your clients, that will be fine, because they're not interested in filing a civil lawsuit. For others, they may be, and it may be because something's been done to them and they feel like they want redress. But you have people who as well will want to use a civil lawsuit as a political tool to get discovery about certain police practices, to highlight what happened on the street. So once again, we're talking about talking with the client to understand what it is they want, and not recommending any kind of a resolution without the client understanding what it means. And so this is just basic, black letter law criminal defense. But I think it's important to understand that some of those basic criminal defense tenets are still applying, even though we're talking about a very unique area here of the First Amendment. We're still criminal defense lawyers, and so it's still the exact same kind of thing.
Absolutely. And hopefully I've helped give a little First Amendment framework to using those tools. But fundamentally, these are things that you guys know how to do. And so just to do a quick overview of the kinds of constitutional issue spotting you're going to want to do when you're representing protesters. The first is, of course, look for First Amendment violations. And we've gone over what those might look like. But the first is you want to be on high alert if your client is arrested in a public forum, meaning a street, sidewalk, or public park. You want to be very alert to any defenses against the element of intent and any quirks in your individual state law. And you want to get all that factual discovery that Jeff mentioned that may show that it's not applicable to your client. As you're looking at them, if the law itself looks like it was used in a way that essentially demonizes or limits those rights in public forum space, call your local ACLU, inquire about a facial challenge. Or if discovery indicates you've got a client who didn't have notice of a crime that required intent or claimed that they were given a dispersal order that never happened, those facts are going to come in handy for your as-applied challenges. And defense counsel just meant as in, that's a thank you parenthetical. You guys are in charge of that.
Exactly.
And then some due process violations. We've talked about them throughout, but just to group them together here, for dispersal orders and for interference with a police officer, those are ad hoc crimes. They are defined by the cops in the moment. What that means is that the courts actually care about due process here. And due process always gets a little thumb on the scale when you're making those arguments in the context of potential First Amendment activity, because the courts want to make sure precisely that government actors can't float around and place ad hoc limits on your ability to express yourself. So especially if we're talking about a failure to disperse or interference with a police officer, you want to make sure that your client had actual notice of what the situation that justified that dispersal order or telling you to get away from a police officer. And in the dispersal context, not just notice, but a meaningful opportunity to get away. That really matters. In Baton Rouge, there were protests that were held on the street. The cops boxed people in, gave a dispersal order from the street, shoved them onto private property, and then gave a bunch of people tickets for trespass.
Exactly.
And fortunately, those claims were waived because the property owner came to court and said, over my dead body, nobody was protesting on my lawn.
Exactly.
Or nobody was trespassing. Sorry, she was with the protesters. So that ended up okay. But had those charges gone through, that would have been ripe for a due process that those folks, even if they heard the orders loud and clear, had no opportunity to disperse, and that is a critical element of that crime because of its ad hoc nature. The next one, as we've mentioned repeatedly, look for that mens rea or that specific intent. A lot of these protest-related misdemeanors have that specific intent precisely to make sure that they're constitutional and they're not over-applied to people who don't intend to obstruct traffic, for example. And individual proof, what I mean by that is we have some great case law from the civil rights era,
Right.
including NAACP. We have the NAACP to thank for NAACP versus Claiborne Hardware, where the Supreme Court has said, particularly in the context of a protest, the risk of treating people like co-conspirators is unbelievably high in terms of censoring protests. Because if somebody thinks, hey, if the guy next to me decides to throw a brick through a window and I'm
Right.
looking at felony charges or I'm going to lose my house, I'm not leaving the house.
Exactly.
And by the way, one of those awful protest bills we've mentioned, Arizona, which passed the Senate and the House in the dead of the night, and thank God, one of the Senate leaders said, it's not going anywhere over my
exactly.
dead body, but literally said if you went to a protest and there was illegal property damage, your house could be subject to civil forfeiture, right? Just to scare the bejesus out of
Exactly.
anyone thinking they might
Just
leave
to
their
say,
house to
don't
protest.
come to this
Yeah.
protest, and you won't have a problem.
Right. So if you've got a client who said, I wasn't near that brick, I didn't come with those folks, again, you should have a slam dunk defense because the elements of individualized due process and individual proof of those elements get real scrutiny from the federal courts in the context of a protest. There's good law on this.
And so if you think back to the WTO protest in Seattle, and I know this is going back a number of years for some of the younger people, but there were anarchists at that protest who were dressed in black, had black masks on, had masks on for the intent of hiding their identity. And they engaged in deliberate, planned acts of violence. There is no way that the other folks who were down there protesting could have any responsibility for what the anarchists did, knowing what they were going to do, or even seeing that they did it, still standing there to protest. So I think this is a really important issue in terms of that individual proof in mens rea.
And then the final one I'd just throw in here, we haven't talked about it a lot, but just is vagueness. As I mentioned, due process gets a little extra spice when you're talking about due process in the context of First Amendment rights. And so if you ever have a client that says, or you look at a law and you're not crystal clear on what that law says, right? Like, I don't know what it means to be near or around, right, a law enforcement or a sensitive property or something like that. Vagueness challenges actually work in these cases. They're harder as applied. They tend to be more effective as a facial challenge, but it's not a death knell. If you have a law that you as an attorney are thinking, I'm not exactly sure how I behave at a protest and don't get arrested, go for a vagueness and due process challenge. And then Fourth Amendment, we've mentioned those briefly, but this cell phone search is a real thing, and as a practical matter, it happens all the time. A 1983 civil suit might give you leverage, or you may have a suppression motion if there's any evidence that's been obtained from a cell phone against your client without a warrant. Generally, there are no cases holding that there's an exigency exception to the warrant just because someone is standing there with a police officer. They could still take that camera into custody. Touching and deleting photos is going to be, I think, a clear violation of the Fourth Amendment. And the other thing to have a heads up about is the increasing number of invasive social media warrants and subpoenas that are going out, particularly for organized activity. So just be aware of that. Your client generally should get notice from a social media company if their content is subject to a subpoena. They don't always get it with a warrant. And in part, we're seeing this, increase of gag orders. So that's the kind of thing where if you have a mass arrest, you want to be looking at news stories. You might want to connect with your local National Lawyers Guild or ACLU to see, hey, has anyone heard about excessive law enforcement activity around those? They may be hard to sniff out, but they may be things that your client cares very much about.
And let me just say something that's related to this in terms of video. In today's America, there are video cameras everywhere, and many of them are not run by the government. And what I mean is, there could be a store with a video camera pointed outside, and your client or a police officer may be captured on that video. And so, especially if you are dealing with people before a protest, one of the things that you might want to talk to them about is, it could be a good idea for somebody to walk the protest route and just take an account of where the cameras are. And this is not, I'm not saying this to say, so now you know where the cameras are, so when you're going to throw the brick, make sure you're not in front of one of those cameras. What I'm saying is, you want to know where the cameras are so that if some bad shit happens with the police, you know, hey, they may have been captured on one of these private cameras, and the other thing that lets you do is to go to that store the next day. Because a lot of these store videos, they're just recorded over every 24 or 36 hours. It allows you to go serve a subpoena and say, don't re-record over that videotape. We want to have that preserved.
And the final note to look for, you guys probably look for this in all your cases where there's an arrest, excessive force. This, again, will have some real force in a First Amendment context. If we are talking about a peaceful protest, even if there may be trespass involved, or even if a valid dispersal order is given. Earlier in the slideshow, we saw that kind of iconic image of a Berkeley police officer spraying pepper spray at students who were handcuffed. That would be a textbook definition of excessive force, right? These folks are already restrained. There is no risk of them escaping. They're painful pepper sprays being used on them while they're captive. Excessive force. Similarly, if we're talking about peaceful protesters, generally it's our view that practices like kettling massive groups of people and holding them captive, indiscriminately using pepper spray towards groups of people who have not demonstrated any violent tactics towards the police, or pepper spraying a larger audience than say one or two bad apples who the police have seen throwing things. Those are all going to be subject to excessive force claims. And again, I realize that's not a get out of jail free card, but any kind of 1983 claims you may have dramatically increases that leverage for your client. So whether that's something you can do or you can work with another attorney to do, that matters hugely as far as the outcome of your individual case. So the last thing I'll say is just that I am a First Amendment attorney, and I risk, the greatest risk I have is feeling that I work in an ivory tower. And I worry about empowering people with their rights because I know that those rights get abused. And they particularly get abused against vulnerable people, right? I started out by contrasting the Women's March and racial justice protests. There's really no question to me about who's more vulnerable in their interactions with law enforcement, and those are the folks who get arrested. So for me, informing people of their rights is only half, if that, of the battle, because I worry about people taking those rights out into the streets because I can't control whether or not they're respected, but you guys can. And I know that you are always used to, as defense attorneys, kind of functioning in the gears of our democracy, but I think this is a particular role that is so near and dear to what our republic stands for, in the grand tradition of John Adams, to make sure that when the rubber meets the road in the streets, that these rights actually filter down to the kind of people who get arrested, vulnerable people who are challenging the status quo. And I can't do that from behind a desk. So I just want to say thank you. And I remain available through NACDL, through Jeff, with Jeff, if we can continue this conversation in making sure the marriage of theoretical First Amendment rights and the rights respected at the street level continues.
Lee, thank you for that last comment, and I really do think that is the appropriate way to come to close to the end of what we wanted to say, is that there is a difference between the law and living. And an example I'll give you is that on Sunday in the mid-1950s, on the day before the buses in Montgomery were going to be desegregated, there was a list of about 30 things that was passed out in the black community by the Montgomery Improvement Association. And this list was a list of how you should act when you get on the bus tomorrow. One of the things they said is, do not deliberately sit by a white person unless there is no other seat. And this was from the black community to ourselves, because what that list was saying is, we just won this thing in court, but there's the law and there's living. And sometimes the law and living ain't the same thing. And I gave a presentation earlier this year in the Bronx in New York about policing and surviving encounters with the police. And there were members of a dance group from New York called Flexin. And these folks took what I said and worked with other folks at the ACLU to come up with a video that we want to show you as we end this. And I'm going to make a couple of comments about the video after it's done, but hopefully you'll be able to see and hear what's here.
I was just walking, I was going to get something to eat. I'm walking, minding my business, usual way home. There are cops everywhere. Stop and frisk you for no reason. And they look at me like I'm a criminal or something. And all of a sudden the cops, he pulls me aside, he's like, hey, come here. And they'll ask you anything.
Where you going, or what are you doing, where you coming from, and
They'll say, what's the guns, what's the drugs? Why did I just get singled out? As if like I did something wrong. I never thought that would happen. It was just like a natural thing.
Level 138 in progress.
Yeah, they pulled me against the wall, taking guns out.
he said, I didn't search you, I patted you down. Okay, what did I do now? Because it's not fair.
Take a deep breath.
You gotta not let it get to you.
act around police officers, you know? Poke at people. That's my job. Just don't give me anything to poke at.
Knowing your rights, it's like a power. When I go into the street, I can feel well equipped. Words have power, for real.
Learn your rights and take the power that you have.
Be calm, spit your rights, and give people the best chance to be okay.
I've never yelled at a police officer. I never had to. I just spoke and they had to listen.
What you speak into the world will definitely answer back.
I feel like knowing your rights is having a great deed of power.
Because the rights bring you back down to equal terms. No one has power over you, and you have power over nobody. We are the same. That's how I feel about it.
Is incredibly important. And you'll notice that one of the things that the dancers said, knowing your rights, knowing how to act around police officers. We're not talking about respectability politics here. We're talking about staying alive. Knowing your rights and exercising them in a way that doesn't give police officers the excuse to put their hands or their weapons on you gives you the best chance of coming out of it alive and well. It doesn't guarantee that, and we saw that with Philando Castile. It does. So none of this is a guarantee, but I can tell you this. If your client is at a protest and a police officer comes and puts hands on and says you're under arrest, and your client turns and runs, what I can tell you is this. The chance that your client is going to get, pardon my French, it's a technical legal term, an ass whooping, has just gone up incredibly. The chance that they may get shot in the back as they're fleeing has also gone up. And so understanding that knowing your rights, understanding where you can protest, understanding where you can stand and what you can say and how loud you can say it as you're getting close to a government office or official government place, all of those things are critical, and it will give you the best chance to come out of these situations intact. But it doesn't guarantee anything. And anybody that is going to protest, especially, as Lee said at the beginning, when we're protesting about the stuff we're talking about now in America, you are taking a chance. And that's something that I think makes me proud to be a criminal defense lawyer, because if we are representing the people who are willing to put their safety on the line to protest about something that's critical to this country, I don't see how we could ever feel that we do anything more important in our jobs. So I want to join Lee in thanking the folks who have agreed to be volunteers, who have agreed to be lawyers on these issues. We desperately need the help. America desperately needs the help. And as Lee said, if she and I or the ACLU can be of assistance, all you got to do is call. We're not going anywhere.
Great. Thank you both so much for a fantastic presentation. We have two very quick questions, and we have, I think, a few minutes left. Could you talk about additional considerations if the protester or the person arrested is not a citizen? And the second question, I'll just read both of them. In a criminal prosecution of a group of protesters who want to coordinate representation, how do you balance representing your client's interest versus the interest of the group?
Those are great questions.
They are. Want me to try the first one?
Yeah.
And you can tackle the second?
Yeah.
Okay. No question that, especially right now, non-citizens are going to be particularly vulnerable to any arrest. And that's particularly so because until the Trump administration, generally, the kinds of misdemeanors you would get at a protest would not trigger any deportation or removal proceedings. That is no longer true. ICE has made clear, DHS has made clear that their priority now is removal of people who have any criminal infraction on their record. So the stakes are unbelievably high to have a conviction, including a plea, on a non-citizen's record. That might factor into your willingness to fight the charges if there are viable factual or legal arguments to keep that person's record clean. And I think given the extreme vulnerability at this moment in time, and again, the ACLU, our other brilliant colleagues are working to challenge deportation removal proceedings that are unjust and unconstitutional. But at this moment in time, if you have the ability to consult with an immigration attorney who specializes in the potential for collateral consequences, this is an excellent time to do so because really the extra vulnerability is real. And so you just want to make sure that your client is being well counseled for any potential impacts to their immigration status, to their ability to come back into the country if they should leave. And generally, a criminal conviction is going to create the biggest risk, so it just adds to perhaps your desire to avoid that at whatever cost.
And I think what goes there and what goes for the second question as well is part of this is about empowering your client with knowledge so your client can make a decision. And some clients will say, you know what, I'm not going to the protest because I need to stay here and I can't risk getting arrested. Other clients may say, I really don't want to get deported out of this country, but I'm not walking away from this issue. You want to leave it to them. It is their life and their decision, not ours. And I really think that's something important in this area. Be careful about imposing your politics on your client's decision making. It is not about your political beliefs. It's not about whether you think this is an important enough issue for your client to take a chance. It's about what your client thinks. And so when the client says to you, you know, what should I do? The answer is give them the information and then talk with them about what's important to them. The second question about is the difference between being a criminal defense lawyer and a movement lawyer. Mm-hmm. And those are two separate and distinct roles. The way that I always try to deal with this, and you know, it's going to sound like a repeat, but it's talk to the client, and talk to the client immediately. If you're talking to a client before a protest, you can say, so I understand folks are looking to get arrested, and let's have a conversation about, are you willing to do that? Are you willing to get arrested? Do you have bail? Do you have someplace you can live? Is your job set up so that you're not going to lose it? If you're talking to your client before the protest, you can have those kind of discussions. If it is after an arrest, and there is a movement of people trying to say, we want to be tried together, and we want to go to court and bring the same motions all at once, and we want to see how they can try 50 of us at one time. So we want to oppose any severance motions. That may be the group think. What you have to do is to get alone with your client and walk through that. And once again, doing it in terms of informing the client. And so informing the client of, there are some individual defenses that you may have that the rest of this group isn't going to have. And I may be able to walk you out the door while these 50 people stay and have to go to jail. Some clients may say, I want you to go ahead and do that. And if that's what the client wants, then you take that road, you raise the individual issues, and you get the client out of the courtroom. Some clients may say, I understand that, but my choice is that I want to stand with the group, and I'm willing to undergo the consequences if we lose. That's where you have to have the discussion about, let's make sure you understand the consequences. Let's make sure you've thought about this thoroughly. Not to try and change the client's mind, but to give the client the ability, empowering the client to make the decision by himself or by herself so that they can feel good after it. And I have had both situations happen where a client has hugged me as 50 other people are walking to jail because the client's saying, I couldn't afford to do that, thank you so much. And I've also had a client hug me on the way to jail saying, I knew we were going to lose this, but it was more important for me to stand with these people than it was for me to do this thing as an individual. So thank you for helping me do this. If you advise your client and let your client make the decision, then these circumstances which sound difficult all of a sudden become very simple. It's about empowering your client to do what they want.
And they're not always mutually exclusive. I think
That's right.
One great example is there were organized Black Lives Matter protests at the Mall of America. And the Mall of America, being generally private property, effectively filed civil charges and encouraged the city to file criminal charges of basically conspiracy to commit trespass. And as part of this, they were seeking remuneration for the entire police response, which of course was heavy-handed and totally excessive and hundreds of thousands of dollars. And I think I could be wrong, but certainly the vast majority of people arrested stood together, all said they were going to fight the charges, they were going to do it together. They all waived potential conflicts. Most of them shared the same counsel after,
Right.
I think, being duly counseled about the risks of doing that, because some of them had more actively organized than others. So their intent levels,
That's
were all
right.
different. And the power in them doing that, I think, directly contributed to the judge throwing all of those charges out of court on day one.
Absolutely.
Saying, this is bullshit. This is not what these laws were created for. We're not going to go extorting people, out of hundreds of thousands of dollars because they said, let's go have a protest on Facebook. And it was because they did that together that there was power in that. And so even if you get a client that doesn't opt for that, and you end up taking a plea, you, as part of this project, might have bigger First Amendment fish to fry, even if you've done exactly what you need to do for that client. Get the word out to the ACLU, to the local defense community. This is how they're applying those laws. And that's how we build mass challenges that may be a class certification or maybe a facial challenge, knowing how they're enforcing it. So be creative advocates. Your first job is to do what's best for your client. Be open to what that looks like and let your client drive you. But even if that means a more standard plea deal from your position, get in touch with other folks. Let them know if you think these laws are being applied problematically, and we can help protect people in the future.
And Lee just said something that I want to comment on because it's really important. We've talked about the circumstance where you represent an individual client and you're trying to decide, does the client go with the group, does the client go as an individual? What if you are representing 10 people all at once? Conflict waiver, conflict waiver, conflict waiver. And these are discussions that you have to have openly. If you are being careful, you're going to advise each individual, go talk to another lawyer before you agree that I can represent you in joint representation. And then, once again, it's like you put the dead cat on the table and make everybody look at it at the beginning. And so you say, Lee, I'm representing 8 other people, and you know what? I got to say some things for them that aren't going to help you. And I need to know, is that okay with you? And Lee may say, that's okay with me. And then there is no conflict in me making that statement. But if I haven't had that discussion with her, I am now in a world of hurt as a lawyer because I am doing something that will deliberately benefit one client and deliberately harm another client. And you cannot do that within the bounds of legal ethics. So if you're going to engage in the representation of multiple people, conflict waiver, conflict waiver, conflict waiver. You can't avoid that, and it's not something you can leave until down the road. You need to do it at the very first meeting and make sure you can go forward.
I'd give you the waiver, Trone.
And with that, we're out of time. Thank you so much.
Absolutely.
Thanks for having
Thank you,
us.
guys.
Thank you.